Okay, yeah, we're going to go and get started. Thanks everybody for coming out. This is Eric from hrsimple. Glad you're joining us today. We'd like to welcome Lindsay A from Shawe Rosenthal. She's going to talk about EEOC investigations and stuff going on with that. Shawe Rosenthal authors the Maryland Human Resources Manual on hrsimple.com, specifically Fiona Ong. So we want to thank them for authoring that resource. They're a great firm. They've done several webinars with us, and we're happy to have them back. So just a few quick announcements. Today's presentation will last approximately 60 minutes with some extra time for Q&A at the end. hrsimple.com is an HRCI approved provider and a SHRM certification provider. At the end of this webinar, we'll give you codes for both certifications. Please enter your questions if you have any in the chat box, and we'll get to them when we can. A recording and slides will be emailed to all registered attendees after this presentation. We're also posting all of our webinars at youtube.com/hrsimple. And now just a little bit of info on today's speaker, Lindsay A. Lindsay White represents management and employment litigation in state and federal court. She also handles matters before administrative agencies like the Equal Employment Opportunity Commission, the Maryland Commission on Civil Rights, and the Department of Labor. Lindsay provides training to management and employees on discrimination, reasonable accommodations, and other topics. She advises human resources professionals and other company officials on personnel issues and assists them in preparing policies and handbooks. She is an accomplished speaker who has presented to organizations at the national, state, and local level. So yeah, we've got a solid speaker, and we're happy to have her. And with all that said, I'm just going to turn things over to Lindsay, if you're ready to go, Lindsay.
Absolutely.
All right, thank you.
Thanks. Hi, everybody. I'm very excited to be here today to present on this topic, and I wanted to add a little bit about my background. Before joining Shawe, I was a trial attorney with the EEOC for over 6 years, where I litigated a wide range of cases arising under the federal anti-discrimination statutes, as well as provided advice and counsel to EEOC investigators. So I bring that perspective to my practice now at Shawe. And when we titled this presentation "Murky Waters," that was several months ago, and it's even murkier now after the election, because under the Trump administration, there's a lot of uncertainty about how the agency will look and what investigations will proceed and what litigation will proceed under a Trump administration. So it's going to be an interesting ride and an even murkier ride. So with that said, let's get started. Today we're going to talk about the EEOC's systemic program. We are also going to talk about the strategic enforcement plan and how that really guides the Commission's priorities. We're going to talk about PCHP, which is the EEOC's acronym for how charges are assessed, Priority Charge Handling Procedure. We'll talk about investigations, litigation, and also future trends. What is the systemic program? So systemic cases, and this is true of both investigations and cases in litigation, are pattern or practice cases, policy or class cases where the discrimination at issue has a broad impact. And most commonly, you'll see a systemic case where there is a broad class of victims, large numbers of victims, but it can also come into play where there's a policy that is discriminatory on its face or in its impact. And the EEOC created this program formally in 2006. So it's been around for 10 years, and it really signaled that this is the Commission's priority, and it has been and continues to be the wave of the future. And the stated reason for this is because it allows the agency to optimize its resources to affect the greatest number of people. And the Commission does dedicate a lot of personnel to this effort. For example, there are lead systemic investigators and attorney coordinators for this program throughout the agency. And as part of this program, the offices, the various field or district or area offices across the country are required to identify systemic cases early. Why does this matter? So this matters, like I said, because it has been around for several years. It's continuing to be a tremendous priority for the agency. And the Commission's strategic plan sets a target percentage of the EEOC brought litigation that will be devoted to systemic cases. And the EEOC, in addition to investigating charges of discrimination, does bring lawsuits. So, a small number of those cases become lawsuits that the government itself brings. And many of the cases that the EEOC brings are these systemic cases. And here's a very telling statistic. Over the past 5 years, the Commission has increased its systemic investigations by 250%. And at the 10-year anniversary of this program, the Commission released some documents reflecting on the success or scope of the program, and announced that it has resulted in some form of relief for over 71,000 individuals since its implementation. And in addition, in February 2012, the EEOC commissioners, the 5 commissioners, again reaffirmed their commitment to the systemic program by through a vote with the strategic plan for the fiscal years 2012 to 2016. Another interesting statistic is the EEOC also tripled the rate of successful voluntary conciliations of systemic investigations from 21% in fiscal year 2007 to 64% in fiscal year 2015. And I think the reason that you see such a large increase is because when the EEOC either investigates or litigates these systemic cases, they generally, the outcome of them is, if they result in settlement or something like that, they result in tremendous amounts of money. And we're going to talk about that later when we talk about conciliations. But these systemic cases, whether it's in the investigative stage or in litigation, take a lot of resources to defend, and there's the potential for a very, very costly resolution. So definitely that is something that should be on everybody's radar. And in addition, why the conciliation rate is so high is of the systemic cases that the Commission itself brings, it has a 94% success rate, meaning that it's either won through a motion or obtained a settlement. And these types of resolutions are very often in the 7-figure range. So it really is a staggering statistic, and we're going to talk about what types of charges become systemic investigations. But if you find yourself in a systemic investigation, you should really consider very seriously what the best steps are, and that may well include resolving it while it's in the investigation stage. Okay, so what types of cases are eyed for systemic investigations or litigation? These are generally 3 broad types. So class allegations, pattern or practice cases, charges that are allege a facially discriminatory policy, and charges that allege a facially neutral policy that has a disparate impact. So we're going to get into the Commission's strategic enforcement plan in a few minutes, and that is where the EEOC has articulated 6 priorities that it's going to focus on, and it just issued a new strategic enforcement plan this fall, and the priorities are pretty similar to what they were before with some modifications that we'll discuss. But the strategic enforcement plan is actually very helpful because it gives employers a sense of, you know, what the agency is going to focus on. So the first category here, class allegations or pattern or practice. You see a lot of failure to hire cases. For example, failure to hire African American workers, or a current case that's pending against Texas Roadhouse, failure to hire workers that are over 40 for the front of the house positions. And then charges alleging a facially discriminatory policy. So for that, for example, that could be an English-only policy, depending on the implementation, but a policy that on its face is discriminatory. And then the third area, charges alleging a policy that is facially neutral but has a disparate impact. A prime example of those, and you've seen a lot of these cases over the years brought by the agency, are criminal background check cases. So those are neutral on their face because everybody's undergoing the same criminal background check, but as most of us know, there is a higher rate of incarceration for African Americans, Latinos, and men. So those criminal background checks have the potential to have a disparate impact on those protected classes. Okay, so what is the strategic enforcement plan? As I said, this is a plan that the Commission has released. It recently updated the plan. The previous plan was from 2012 to 2016, and it sets out 6 national substantive priorities for enforcement and litigation. And one of the purposes of the strategic enforcement plan is to make priorities consistent across the country, and the other stated purpose is to make a sustainable impact through strategic law enforcement. And individual districts are required to adopt their own district complement plans, and those should all be available. And so depending on what district you are in, your district may have adopted additional priorities. For example, perhaps some of the western states have a priority that would affect something having to do with tribes, or where I am in Maryland, the Eastern Shore, there can be implications for that. So this really is a blueprint for the agency's litigation program. And here are the 6 priorities, and we're going to talk about each of them individually. And the first one is eliminating barriers in recruitment and hiring. So this pertains to protected classes based on race, ethnicity, religious groups, also older workers, females, and individuals with disabilities. Some of the theories that come into play here are the theory of channeling. So for example, if a female applicant comes in and applies to work in the warehouse, but instead is steered to work in an office, that can be an example of channeling. And then something else that could come into play here are restrictive processes. So for example, let's say an employer has an online application policy, or online application, people apply for positions online, but those systems are not accessible to people who have disabilities or people who have, speak other languages. So that would be a barrier to recruitment or hiring. Another way this priority could come into effect is through job segregation. So that means people are, once people are hired, it's not that a company doesn't hire African Americans, but once they do, they are all put on one team and they're put in the African American neighborhood. So that's an example of job segregation. And then here is where, where we talked about the criminal background checks, that would come into play under this priority. So that would be a screening tool with the potential for a disparate impact. In addition, and this was one of the new priorities that was added into the new strategic enforcement plan, but the temporary/21st century workforce. And this is really a hot issue across the agencies. Department of Labor has taken up, they've taken an issue with Uber and, their practices, and this goes to the on-demand and the gig economy. So are these people, for example, who are Uber drivers, could they possibly be considered employees? Those types of issues and these flexible arrangements that we didn't have as a society until recently, those are really going to be the wave of the future and something to really consider. Another issue is big data as a selection device, and the Commission held they held an event around big data. They held a meeting about it this fall, and that's always a good indication that that's something that the Commission is seriously considering. So I wouldn't be surprised if we see some guidance, some specific guidance on that issue at some point in the near future. And big data is a selection device that is using predictive analytics or talent analytics or data scraping of the internet to make hiring and other employment decisions. And the potential for that, there is some potential for that to have a disparate impact on some individuals. Okay, so the second priority is protecting immigrant, migrant, and other vulnerable workers. And so this really focuses on, as it says, the immigrant, migrant workers. And things that are important to be aware of here is, depending on your workforce, being aware of incidents involving non-native English speakers and undocumented workers. And the guidance, the strategic enforcement plan specifically referenced work status and language as a basis for exploitation. Priority 3 is somewhat of a catch-all, addressing selected emerging and developing issues. So this, in the plan, it identifies issues that are currently emerging, but obviously, who knows what's going to be the next emerging issue. So the trends identified were qualification standards and inflexible leave policies. Inflexible leave policies are, they've been something that's been a priority for quite some time, and that comes into play, for example, when oftentimes a company has any leave terminate at the end of FMLA. So without the recognition that additional leave could be warranted as a reasonable accommodation under the ADA, or in cases where either the employer is not covered under the FMLA because they don't have enough employees, or the employee, his or herself, is not covered because for whatever reason they don't have enough hours. This also covers accommodating pregnancy-related impairments under the ADA and the PDA. So after the ADA was amended in 2009 to give more expansive coverage for plaintiffs, many pregnancy-related conditions can now be covered, are now covered under the ADA. So this priority addresses that intersection. LGBT issues. LGBT issues have been a huge priority, excuse me, for the Commission recently, and that starting really with summer of 2015, where the Commission itself issued Baldwin versus Department of Transportation, which recognized that because of sex includes because of sexual orientation. And following that, the Commission filed 2 lawsuits on the basis of sexual orientation in March 2016. One of those has resolved, and one of those is still pending. So the courts are still not settled on the issue of whether Title VII includes because of sex, includes because of sexual orientation, but it is now very clear that that's the Commission's position. So again, that is something to be aware of. And transgender status is more settled within the courts under a sex stereotyping theory, and the Commission has also brought several transgender lawsuits. And another priority here is the complexity of workplace relationships. So temporary workers, staffing agencies, situations where an employee has, 2 potential employers. That's another priority. Independent contractors. And then this was a new priority added under the revisions, which is discrimination against Muslim or Sikh individuals and people of Arab, Middle Eastern, or South Asian descent. And that is in recognition of, some retaliation against those groups that occurred, have occurred in recent years. So another thing to keep in mind here is just this week, the Commission released a guidance document on depression, PTSD, and other mental health conditions in the workplace. So that may be a clue as to, those disabilities being considered an emerging issue. Ensuring equal pay protection for all workers. So previously, this priority was expanded and was focused on equal pay protection because of sex, but now it is expanded to include, race, ethnicity, age, disabilities, any protected groups. And I think that you'll continue to see that, cases under this Equal Pay Act continue to be a tremendous priority. Preserving access to the legal system, and really the big one under this is overly broad waivers, releases, mandatory arbitration provisions. Again, this seems to be a tremendous priority for many of the government agencies. We've seen a lot of aggressive enforcement of these between, across the various agencies. So this is definitely something to have on your radar, and make sure that your releases and waivers and any documents that you have that that language, that the language is compliant and not overly broad. And one of the big things to consider is having not prohibiting access to participate in the EEOC's investigations or anything like that. Making sure that employees, it's very clear that they can participate in investigations that government agencies conduct. And another issue here is failure to maintain and retain applicant data as required by regulations. And then the third one here, retaliatory practices that dissuade others in the workplace. That language really tracks a Supreme Court case of what the definition of retaliation is. And then finally, preventing systemic harassment. Harassment is and has been one of the most frequent complaints in the workplace, and over 30% of EEOC charges allege a harassment component, with the most frequent being sex, race, disability, national origin, and religion. So oftentimes you see if the Commission brings a lawsuit, a harassment lawsuit, you do see it will be of a fairly large scale, and if not, it will have some other priority, for example, vulnerable workers like very, teenagers or perhaps vulnerable for a different reason, migrant or immigrant, or extremely egregious harassment. Okay, so with that said, those are the priorities as are outlined in the Strategic Enforcement Plan. So now let's talk about what triggers an investigation. Investigations can be triggered in 3 different ways, and the most common by far is an individual charge. Somebody comes in through the door and they file a charge of discrimination against their employer or prospective employer. The second way an investigation can be triggered is through a commissioner's charge, and those are fairly rare, but they still happen, and those are triggered when a commissioner actually signs the charge, and that triggers an investigation just like if a charging party walked through the door and filed a charge. And the third way that an investigation may be triggered is through the Equal Pay Act or under the Age Discrimination and Employment Act, and because those have a different statutory scheme than Title VII, ADA, and GINA, those may be started by a directed investigation approved by a director. And just to provide some context, in fiscal year 2015, the EEOC received just under 90,000 charges of discrimination. So the odds are good that at some point an employer, even if you're a smaller employer, will find yourself on the other end of an investigation. Okay, so the next slide talks about priority charge handling procedures, or PCHP, and this is, the Commission has come up with this classification as a way to assess the charges as they come in the door, and they're grouped into 3 categories: A, B, and C. So A is obviously what the Commission is going to devote more of its resources to. B, most of the charges get the B assessment, and then C, those are the charges that typically should be where the office has insufficient information to conclude that further investigation will result in a cause finding. So things like lack of jurisdiction, but we'll talk about all of these in more detail. So these assessments are considered privileged by the Commission, and these, how your charge is assessed will not be shared with you. And this is done, so that the Commission can prioritize how to investigate and spend their resources, because, as I just said, in a recent fiscal year, there were almost 90,000 charges of discrimination. So you have to have a method by which to evaluate and, decide which charges get more attention. So the A charges, those are the charges that will probably result in a cause finding, and those are the ones that are given more priority by the investigators. And that may involve, you may find that you have, if your charge is assessed as an A, you may have an inkling of that because your investigation is moving quickly. You have a more detailed investigation. So for example, you get requests for information right away, you get, you have an on-site investigation right away. All of those would be clues that your charge has been assessed as an A. And oftentimes this would implicate a strategic enforcement plan priority and or is a systemic case. So B charges, the vast majority of the charges are going to fall here, and as defined by PCHP, the EEOC will investigate as resources permit. And these are charges where it's not when it's assessed, it's not possible to make a judgment regarding the merit, and may initially seem to have some merit, but requires additional investigation to determine if there's going to be a cause finding. And then C, the C charges, those are, for example, if a charge is filed against a company and the company only has 5 employees, that company is not going to be covered under Title VII, so there's no jurisdiction under which to investigate. Or if somebody comes in and their only allegation is from 2 years ago, well, that's going to be time barred. So that would be assessed as a C and should be closed right away. So after somebody files a charge, or there's a commissioner's charge that's triggered, a respondent should receive the notice of the charge with a perfected charge within 10 days of receipt. And what that does is it notifies you that the agency has received what's called a minimally sufficient charge, and that a perfected or a signed charge will follow. So typically the notice will tell you, the respondent, obviously your name, the charging party, and usually it tells you the statute under which the charge is going to be filed. And then after the charge is perfected, you should receive notice of that as well. And usually that comes with a request for a position statement or an invitation to mediate through the EEOC's mediation program. So mediation, not all charges are selected for mediation, and that is within agency discretion. So if there is a charge that the agency is very interested in, that may not be offered to be sent to mediation, but you can always request mediation if that's something that you are interested in. And both parties must agree to mediate for it to go to mediation. Okay. Why request mediation? The EEOC's mediation program has a success rate of over 70% according to its documents. And there's no charge to participate in mediation. So the nice thing about it is it gives both sides an opportunity to explore the possibility for resolution at a very early juncture before, particularly before the employer has spent time and money and resources preparing a position statement and gathering documents, conducting a lot of witness interviews. And without incurring attorney's fees. It can also give some free discovery if the charging party shares additional information at the mediation. And it's also the only way to get a charge completely dismissed, because even if the charge proceeds to investigation, and let's say the charging party is represented and you're able to reach an agreement later and the charging party asks that the commission dismiss the charge as part of the agreement, the EEOC does not have to do that, and can in fact continue to investigate that charge. So going to mediation is the only way to ensure that a charge is completely dismissed. Of course, there's always the chance, an opportunity to conciliate a case, but that comes at the end of the investigation after there's been a cause finding. So, we always encourage our clients to very strongly consider participating in mediation for all of those reasons. Okay, expansion of scope letter. At some point in the investigation, the commission may issue a letter that tells you that, they're taking the charge that is against you and they're expanding it to cover a group of people. Perhaps let's say that it's a, a sales manager. So they're expanding it to cover all sales managers in Region 5 or all sales managers nationwide, or and expand the time. So going back from present, 5 years, so back to 2011, who were potentially impacted by the alleged discrimination, or so if you find yourself receiving an expansion of scope letter, I don't think I need to tell you that that's not a good sign, that the agency is taking an interest in your charge and is looking to see if there are other potential aggrieved persons that could potentially form a class. So, that will put you, if you receive that, that puts you on notice that, aside from just responding to about this charging party, you're going to be responding to a group of individuals. And there's really not anything that you can do to resist an expansion of scope. Typically, I mean, we're going to get to subpoenas and requests for information in a little bit, but the case law is extremely favorable for the government and in terms of what their subpoena powers are during the investigation. And, regardless of whether the charge appears to have merit or not, the investigative powers are very broad and powerful. So we'll get to that in a minute. So if a charge goes to mediation and doesn't mediate or doesn't go to mediation at all, typically the next step in an investigation is for the respondent to submit a position statement. And position statements should always contain the following: an explanation and identification of all related employment policies to show that you're committed to equal employment opportunity and equality in the workplace. Obviously, you're going to want to respond in detail to each and every allegation that is in the charge, so a full response to all of those. You may want to have a brief statement of relevant case law. It really depends on the charge. If it's a run-of-the-mill sexual harassment charge, it may be unnecessary, but if it's something where it's an emerging or developing area, it may be prudent to have it in there. And then finally, an analysis section stating why the charge has no basis. On the EEOC's website, there is a document about writing an effective position statement that's very helpful to look at because it gives you a sense of what the Commission is looking for in their position statements. And, aside from the position statement, it's a good practice to submit supporting documentation, and that would include related employment policies, the charging party's personnel file, comparator information, if that's relevant, and a documentation of all complaints and the employer's responses. So obviously, the related documents are, it's going to depend on the specifics of the charge. But if you're, working on a position statement, that's definitely something that you want to think about. What are the documents that I can show to demonstrate that there was no discrimination? And this can also include emails or text messages. That seems to be how more and more employment decisions are occurring. So always something to think about. At the beginning of this year, the Commission made a blanket policy that all position statements are now provided to charging parties as a matter of course for their rebuttal. So it's streamlined. The practice used to vary, depending on the region or the office, but as a matter of course, that's what happens now. So because of that, it's really important to nail down your position statement before you submit it. And if that requires an extension, so you can fully investigate, then that's what it's going to take. But shifting rationales, even if they're inadvertent, can be evidence of pretext. So it is very important to make sure that you have the full narrative of what happened before you make a submission, and consider having an attorney prepare or at least review your position statement, to ensure that everything in there looks good. And there was a recent case this year, actually out of Alabama, that emphasized the importance of capturing the full and complete story in your position statement, and saying that position statements are company admissions and can and will be used against you. So that is very important. So the other thing to note here is handouts are not typically provided to the charging party. So you can mark those confidential, especially as they relate to other employees' information. After you submit a position statement, you may receive a request for information, or an RFI, and commonly sought information includes employment policies and practices, any information that relates to the charging party and the allegations of the charge, so personnel files, applications, if it's an ADA case, medical information, you might see requests for relevant emails. You may have a request for an employee roster with contact information. You may have a request for comparator information. So if, let's say, the allegation is somebody was not hired for a particular position, you will likely be asked for all of the applicants and the person who was selected. You may also be asked for electronically stored information, or ESI, that relates to the charge or charging party. So, and this will really just depend on the charge itself. If in a failure to hire case, it would, I would expect there would be less ESI available. But if somebody was a long-term employee and then was fired, you might find yourself having to respond with emails related to the termination decision. And just a note here, under the statutes, there is a requirement that the agency keeps all of the information it receives during an investigation confidential while it's in that investigation. So, sometimes employers are inclined to object to some of these requests based on confidentiality concerns, but that is protected by the statute, and courts have noted that in their opinions related to subpoena enforcement. So that's not considered a valid concern because there is statutory protection for it. So can you push back on a request for information? It depends. It's worth trying to reach an agreement with the investigator on the scope of a request for information if you think it's really overbroad, it's really burdensome. There's absolutely no harm in picking up the phone or sending an email and trying to reach some agreed upon parameters. Or, one approach that you could even take, if, let's say, they're asking for 5 years worth of information, perhaps you could agree to 2 years, and then, with the caveat that if they really can show you that they need 5, you could revisit it later, something like that. Alternatively, you can respond with what you believe is reasonable. So if they're asking for 5 years and you think 2 is reasonable, you can respond with 2 and, see what happens at that point. But it is not advised to ignore a request for information. As I said, the EEOC has subpoena authority, and that, the courts have generally recognized that that is very broad. So, you know, if you don't provide any response to an RFI, you really put yourself at risk of receiving a subpoena and, you know, finding yourself eventually in federal court defending against an administrative subpoena, which is not a position you want to be in for a variety of reasons. So I always think it makes sense to try to reach an agreement if, you know, you believe a request for information is overbroad. Subpoena authority. So this slide gives the Title VII provision where you know, the Commission has subpoena authority. So it's worth noting that subpoenas that are issued solely under the Equal Pay Act or the ADEA are a little bit different. So those are immediately enforceable in federal district court upon non-compliance. But other subpoenas, so those issued under Title VII or the ADA, those fall under a different kind of mechanism. So if you're served with an administrative subpoena and you object to it, or you know, you want to fully object or partially object, you can file a petition to revoke or modify, and that I've cited to the code there of where these, you know, guidelines are articulated. It spells out the procedure for that. And the thing to note about this, and this is very, very important, is you only have 5 days, excluding Saturdays, Sundays, and legal holidays, after receiving the subpoena to file your petition to revoke or modify. So that is a very, very short time frame, and it can be used as a basis to deny the petition. So, you know, if you've received a subpoena, do not ignore it. Do not wait to deal with it. Look at it and, you know, figure out your course of action. And at that point, you know, you can file a petition that explains all of the reasons that you think it's not appropriate, or alternatively, if you would like a modification. And at that point, you know, the determination will ultimately go to the commissioners. So there are 5 commissioners, and they will issue a decision. And once they issue a decision, the determination may limit the scope of the subpoena, may fully uphold the subpoena, or invalidate the subpoena. And the determination will include a time for compliance, after which the EEOC legal unit of the office conducting the investigation can compel enforcement. So again, as I mentioned earlier, when considering whether you should comply with a subpoena, again, the case law is very favorable to the Commission. When the judge is determining whether or not it should be enforced, the judge cannot consider whether it's likely to result in a cause finding. So, you know, it really just it's a very lenient standard. So, you know, that is a huge consideration in trying to determine whether you should comply with an RFI or if it goes to a subpoena. And again, which is why I think going back to the request for information stage, if you can reach an agreement as to the scope, you know, that your client or you can live with, it's always worth doing that, I think, because you can save yourself getting to the stage. And of course, a reason to avoid a subpoena is if it presents an undue burden. But again, the standard is very, very high. As you know, the court, this Fourth Circuit case that I've cited says the burden of proving that an administrative subpoena is unduly burdensome is not easily met. So to do this, you would have to submit declarations showing the number of hours and cost that it will be to the, you know, to you, and that it will severely disrupt business operations. But if you look at the facts of cases where courts have rejected undue burden arguments, I mean, they've rejected those. For example, in this case that I've cited, where the employer said that it would cost $75,000, and that's in $1985, and the court said that that was not unduly burdensome because the company didn't show how burdensome it was in light of the normal operating costs. So again, this is very difficult. It's a hard showing to make. Okay, so another aspect or place that you may find yourself is having an on-site investigation with respect to your charge. And, you know, some things to be aware of. Be aware that managerial employees can bind the company because those can be later used as statements against interest. So it's really important that in preparing for your on-site investigation, you know, that the witnesses are, you talk to the witnesses and just, you know, be aware of how important what they say actually is. So obviously, oftentimes attorneys are involved in this process and, you know, help the witnesses prepare in advance. And again, interviewing employees is within the agency's investigative power, so it's pretty difficult to avoid an on-site investigation, if not entirely impossible. So another thing to be aware of during an on-site investigation is investigators often look for what's called technical violations. So aside from conducting interviews, they will be looking for record keeping or commingling violations or failure to post EEOC posters. So that's something to keep in mind as you're preparing for an on-site, you know, to make sure that you are in compliance with the more technical aspects. Okay. Some special considerations for systemic investigations. These investigations can take 5 or more years. They are very complicated. Oftentimes, for example, in a failure to hire case, that is going to involve oftentimes applicant flow data. You know, there is just a lot that goes into those types of investigations. They can involve multiple requests for information, 1 or more on-site investigations. So those can really last quite a long time. And one thing to think about is, you know, if you find yourself in one of these lawsuits, to consider a laches argument if there has been any undue delay in the agency's part in moving the investigation along. So obviously, if anybody's been through the charge process, you know that there are many different ways that a charge can resolve. There can be a predetermination settlement. It can be dismissed, a finding of no cause. It can be, as we talked about, mediated. Another possible resolution is a cause finding. So the letter, so if that were the case, the EEOC would issue a letter of determination that would have an invitation to conciliate, and then there would be a conciliation proposal either with the letter of determination or shortly thereafter. And a word on conciliation. So the EEOC is statutorily required to attempt to resolve findings of discrimination through informal methods of conference, conciliation, and persuasion. The only exception to this is there is no conciliation requirement under charges solely under the Equal Pay Act. So theoretically, the commission can go straight into court without trying to conciliate, but those often have a Title VII component which would have to be conciliated. So in conciliation is the process where the EEOC, the charging party, and the employer attempt to resolve the matter. And if there's been you know, obviously if you've gotten to conciliation, you've had a cause finding, and this is your last chance to resolve the matter before it's public. So if you're able to conciliate it, it never becomes public. The only time it becomes public, because I have seen, press releases referencing conciliation, but the employer would have to agree to that as part of the conciliation. The government or the charging party, the government cannot just publicize a conciliation without consent. So the EEOC's obligation in conciliation, the Supreme Court in 2015 considered the case of EEOC versus Mock Mining, and in that case, the Supreme Court considered whether there was judicial review of conciliation, of whether the agency satisfied its statutory obligation to attempt conciliation. And the court concluded that, yes, there is judicial review, but the review is very narrow, and the EEOC has extensive discretion to determine the kind and amount of communication with employers. So, and in that decision, the court said that in normal circumstances, a sworn declaration that conciliation occurred from an agency official will normally suffice. Again, the mechanics of conciliation, you'll receive an LOD, the conciliation agreement, and what the conciliation agreement will typically have is both injunctive or non-monetary relief and then monetary relief for the charging party and or the class of individuals. And typical injunctive relief would include a training requirement, perhaps a policy change or implementation if the policies that were in place were not sufficient, a notice posting. It will also have a duration of the conciliation agreement, so perhaps 1 or 2 years. And then there will be a monetary component in almost all cases, and that depends on what is alleged in the charge, so whether or not there's back pay and eligibility for compensatory and punitive damages. The injunctive relief may also include reinstatement, a reasonable accommodation, hire or promotion, or a salary increase. It just really depends on what's in the charge of discrimination. Some things to consider in conciliation. So do not let large initial demands deter you. I mean, this is, it's a negotiation. So even if the number seems very large and there's no, you feel as though there's no point in responding, it may make sense to respond and explore and see if there's any possibility for a resolution if that's of any interest. It can often make sense to at least attempt, and put some amount of money on the table. And again, conciliation agreements are confidential, and you can likely negotiate a release for if there are any other potential areas of liability. You can often negotiate a release for non-EEOC covered matters. And special considerations for systemic conciliations. If you find yourself in this position, again, think about these cases are very time consuming and expensive to litigate. They last for a long period of time, and oftentimes when they go through litigation, they result in large settlements. For example, a case that the EEOC brought against Zoria Foods was resolved against Z Foods in July of this year by court order for $1.47 million. It was a systemic sexual harassment and retaliation lawsuit. The EEOC settled a case against BMW out of South Carolina back in 2015 for $1.6 million in relief and job offers for up to 90 applicants. And that was a disparate impact case alleging that a failure to hire due to a failed criminal background check had a disparate impact on African American employees. And then also another case out of Kentucky, EEOC versus Walmart stores, settled in for, I think it was 2010, settled for $11.7 million for 4,000 women and 150 job offers. And the allegations there were that the defendant failed to hire women, and that was a 5-year consent decree. So again, I mean, these are big numbers. So if you find yourself in a systemic case, it's worth thinking long and hard about whether or not you can conciliate it. Okay, and briefly, because I know we're running up against time, and I will take any and all questions that people may have. Litigating cases against the EEOC, it's not necessarily particularly difficult particularly different than litigating against private plaintiffs, with a few exceptions. So, obviously EEOC attorneys have no billable hour requirements, so that may change how cases are litigated. There may be more discovery. They're not dictated by what their, individual an individual plaintiff's attorney would be dictated by the demands of that client. And then FOIA considerations. So typically you will not be able to get a charge file if the case ends up in litigation against the EEOC, because that would be viewed as duplicative of a Rule 34 request for documents, so which is served on a party. And then settlement concerns. Any settlement against a government will have a publicly filed consent decree, injunction, training, and almost always will come with a press release. So that's another thing to consider. And just briefly, systemic cases, litigating those against the government, those can last 5 to 10 years. You will almost certainly need an electronically stored information expert or more than one expert or vendor, and liability experts. And it may make sense to consider if bifurcation is appropriate. And then finally, these future trends, I'm just going to list them. We talked about them earlier. I think we're going to see, continued equal pay enforcement with the EEOC's data collection, which is starting in March 2018 and affects employers with 100 or more employees and federal contractors or subs with 50 or more employees. The release, severance agreement, mandatory arbitration, that's going to continue to be an area of interest, as well as big data, the 21st century workplace, wellness plans. The Commission issued final guidance on wellness plans this year, and then LGBT issues, as we discussed. So thank you, everybody, very much, and I am happy to take any questions that anyone might have.
Thanks, Lindsay. We did have a couple questions that I think I sent you, but I can read them off if you haven't seen those in the chat. Okay. Brian, we had a question from Brian. He said, how long is applicant data to be maintained?
That is all by statute, and I want to say it is 2 years under statute.
Okay. And then we had one other question from Penny. She asked, are you able to provide formal documentation on the EEOC's requirement for data required to retain for applicants?
Yeah, I would be happy to. If you're sending out these slides, Eric, I'd be happy to, include a link to that information.
Okay, yeah, I'll make sure in the follow-up email we include that link. Yeah, I'm not seeing any other questions. Thanks, Lindsay. Great presentation. Right now you can see your SHRM and HRCR codes, so you should be able to write those down. Can you go ahead and flip over to the last slide, Lindsay?
Sure.
Okay, yeah, I just wanted to get, sorry, the headline's a little messed up, but wanted to get Lindsay White's email and my own email. If you have any questions, I'm not seeing any others come in, but I'm sure Lindsay would be happy to help you, and if you need anything for credits or otherwise, definitely hit me up. Yeah, I'm still not seeing anything, so I guess we'll go ahead and wrap it up here. But Lindsay, do you have any final words before we do that?
Well, thank you everybody for participating today, and again, please feel free to reach out directly if you have any further questions.
Okay, great. Yeah, thank you everybody for joining. Yeah, we'll go ahead and sign off for hrsimple.com and Shawe Rosenthal. Thanks for attending, and we hope to see you again.